Well, here I am again, your friendly, dangerous dinosaur, coming to you from wonderful Palm Desert, California. I had a scare yesterday and thought maybe I had kidney stones, but the doctor said that wasn't the case and recommended I go down to a lower altitude so I could breathe more easily and not have the problems I've been having lately. So I can breathe and function without altitude down here. And I thought I would also do a little strength and conditioning because I could move around without oxygen. But so much for me. Now let's talk about important things like feedback loops. I remember several years ago when I took a computer course at CU involving, I think, COBOL or Fortran or something like that. We discussed feedback loops. We also discussed that in research design courses and all kinds of things. And it was important that if you go to all the effort of designing something to find out information or to measure something, that some way, somehow, this should be verifiable. It's not planetary science. It's just basic logic. If you want to know whether or not the moon is made out of blue cheese or green cheese or yellow cheese, you send something up there that can analyze it. And maybe it comes back dust instead of cheese. Well, you won't know whether it's cheese or dust until you touch it, feel it, smell it, or some other way, or in some other fashion, analyze it. You just can't take a poll and say how many of you think the moon is made out of cheese and how many of you think the moon is made out of dust. And whoever wins the poll wins the factual determination. That's just complete and utter bullshit. So, judging from changes in law, when I first started, we had common law. Common law tried to determine whether or not a person was a bad guy as opposed to an act being a bad act. So if a person's a bad guy, you do something to either rectify that or to isolate the badness or whatever. You do something. If you're looking for bad acts, it doesn't matter what the guy's like. He might be some unfortunate person that just had a black cloud over him and all kinds of bad things would happen to him. We can't really do much about the black clouds that hang over people, but we can, if we try to punish the darkness, have a feedback loop to determine whether or not our methodology is sound or valid. Now let's take that into social situations. When I started practicing law, very few prosecutors were professional prosecutors. They were lawyers, and they did trial law or transactional law or whatever, but they didn't take up sides. It wasn't a partisan show. It wasn't a Broncos versus Chargers thing. It was search of justice. And all of the works in the Justice Department tended to work together, or at least theoretically. There were quite a few actually, turf wars going on and things like that. But by and large, the system sort of worked. So, for instance, you had various meetings among lawyers, some of them defense, some of them prosecutors, and a lot of the lawyers did one or the other, and a lot of times both. Most prosecutors back then had part-time jobs as lawyers. So if you took a hard-ass position as a prosecutor, your colleagues would generally come down on you and give you feedback, sometimes to the point of ostracism. You were a member of community. The community dictated behavior by feedback and feedback loops. Well, Nixon came in and decided that the federal government should take over the law enforcement aspect of regulating society. And they started telling everybody that we should have specialists in prosecution. Now, one good example I can think of is when I first started prosecuting, the police would make a few mistakes every now and then, like knock the shit out of somebody. And as an attorney representing a defendant, I was also a member of the attorney community and a third department of government. And I would say to the prosecutor, you know, you broke my client's orbital eyeball socket. You broke his arm in 7 places, or your cop did. The bullet took out his spleen, and now he has to have a transplant. And that was kind of an aggressive traffic stop you made there. And, you know, aren't you a little bit conscious that if you proceed with this prosecution to cover the cop's ass, that maybe the city or county or state might have to pay for the bad conduct of your policeman? And the lawyer handling the case for the prosecution at that time had an ethical obligation not to the police department, not to the crime statistics, not to a certain ideology, a law and order thing, but to the community. And very few prosecutors would malpractice by saying, that ain't in my bailiwick. I don't care. I'm here to prosecute this guy, and your guy was dangerous because he had a weapon in the trunk of his car and had to be taught a lesson. And we don't care if he sues the government or sues the state or sues the city. That's not our job. Our job is to prosecute crime, and your guy's a criminal by carrying that concealed weapon. And it doesn't matter to me whether the cop was a little bit too zealous or not. You know, it's not coming out of my paycheck. Well, that's what happens with professionalization. You don't get a feedback loop. You don't get ostracism from colleagues or comments from colleagues. You don't get any kind of feedback on what's good or bad or ugly or not ugly, or whatever happens. Now, one of the ways that they cut out feedback, one of the more effective ways, was very subtle. The propagandists went in there and said, well, every person should have an attorney. That's very true. But the politicians in the state don't like to pay for attorneys when the press says somebody's guilty. So there's a lot of opposition. The press said this guy's guilty. Why should we get an attorney for him? Let's just hang the son of a bitch after we give him a mock trial or whatever. And the focus was on arrest and conviction. At that time, Inbal and Sowell, criminologists at Northwestern, published a study that it didn't matter after somebody was arrested, whether you put him on probation, put him in penitentiary, or released him, the chance of recidivism depended on whether or not he was caught and how soon after the offense he was caught. So anything beyond that was immaterial. That was for propaganda purposes. So the important thing was catching the person. But that doesn't make good headlines, and that doesn't get voters, and it doesn't shake voters down for money. So we have to have something else for that big shakedown. And that is more jails, more penitentiaries, more lock-em-up scenarios and lock-em-up publicities. Whether or not it's effective doesn't matter because you have the propaganda machine saying it is. So they decided we ought to have public defenders. And before that, you had court-appointed attorneys, and we all did our job. And generally, you had an older attorney appointed and a younger attorney working with them. and was a way of passing on knowledge from one generation to another, and it kept everything pretty much in balance. Well, then they decided to fund public defenders. And it was a statistical game, how many cases could be handled. And the trick to being a judge back then, or it later turned out to be, whether you could move X number of cases from the left side of your desk to the right side of your desk in so many days. And then all of a sudden it became 2X, then 3X, then 4X, etc. The system became ultra efficient. Now, waiting around to appoint an attorney or for an investigator to make sure somebody qualifies takes time. And when they decided to abolish bond or make it different, under the Mitchell administration, you had to hold people then until bond could be set. Well, if you held people for bond to be set and held them to determine whether or not they needed an attorney, that took time and crowded the jails. Also, you couldn't get a client to confess or cooperate or whatever if you had to wait for the appointment of an attorney. So the public defender's office was much more efficient. And the public defender's office was to make sure that procedurally the person received a fair trial. And not worry about some of the minor technicalities like search and seizure, knocking the shit out of defendants, things like that, because they all had to get along in a little group. And they even streamlined it, saying that the head of the public defender's office, the chief judge and the chief prosecutor, should get together all the time and determine what the policy should be, determine what a fair disposition is. So the whole thing became rigged to see how you could move 2X, maybe 3X people through the system in the same amount of time. So when the public defenders first came to be in Colorado, the Colorado attorneys were told that probably no more than 10 to 20% of the cases would be public defender cases. The rest would be done by attorneys. The problem with private attorneys is it's like herding cats. We all had different opinions. We all had various comments, things like this. And the prosecutors, who had the ear of the people, figured this was a big waste of time. In fact, most people read the paper, somebody's arrested, they assume he's a guilty party, and it doesn't matter one way or the other whether he gets a trial or whether or not that trial is fair. So, I can remember a case where I was trying or defending some organized crime figures in a loaded trial where they were staging a burglary for the benefit of a warehouse owner so that the warehouse owner could collect on insurance. They had shrinkage of a few $100,000 a year, and every year these warehouse owners would stage a burglary and file an insurance claim for their inventory shortages. Well, my clients got caught, and they figured since they were staging this burglary, they'd take a few things. So they found $2,000 or $3,000 worth of merchandise that came from this warehouse in their homes, and decided they were the burglars for $500,000 for inventory shrinkage, granted immunity to the warehouse people, and prosecuted the Italians because they had Italian names. And the prosecutor and government in Denver at that time was trying to prove they had an organized crime problem. So, in any event, they had a public defender's office by then, and everybody got referred to the public defender's office first. Public defender's office would sift out, take all the easy cases, make all the dispositions, and unclog the docket, leaving the harder cases to go through the system, which worked fine for the prosecutors and the law and order buffs, but not for the rest of us, and particularly not for society as in general. So a bunch of us were trying this case, and a murder trial started next door. And the public defender started up a murder specialty unit. One of the members was a guy named Dave Watson. And I forget it. I'll think of it in a minute. The other guy. So we're picking our jury, and they're picking their jury next door in the next courtroom. And it went sort of like this. The judge would say, "Okay, are you gentlemen ready to proceed?" And the public defender got up and said, "No, we just got assigned this case a few days ago, and we haven't had a chance to even look at it." Well, the judge says, "You guys are the murder experts. That doesn't matter. We'll proceed anyway. We'll start picking the jury." So they brought in some jurors, and the prosecutor asked some questions, and one of the public defenders got up and said, "Well, I don't know what to ask. I haven't read about the case yet." And started reading about the case and said, "Well, I don't have time to figure out any questions," and sat down. So essentially, the public defender's office was being very passive-aggressive in its handling of it. And you could just see the judge there fuming. So they got through the jury selection, and the judge says, "Well, let's have opening statements." The prosecutor made an opening statement, and one of the public defenders got up then and said, "Well, I don't know what the case is about. I guess I'll reserve opening statement till the end of the prosecutor's case." And the first witness was called. So they get the reports, and they sit and play around for 20, 30 minutes reading the reports. And one of the public defenders gets up after that and says, "I have no questions," sits down. The next witness comes, and the same thing. Well, pretty soon it's lunchtime. And the judge adjourns for lunch. And toward the end of the prosecutor's presentation that morning, the appointed head of the public defender's office comes into the courtroom to observe. And at lunchtime, he takes the men out to lunch. And when it's 2:00 and court re-adjourns, the judge sits on the bench with a shit-eating grin, saying to the public defenders, "Well, are you boys ready to proceed now?" And Keith Watson gets up and he says, "Well, Your Honor, we're not, because we just been fired." The public defender had fired them for not playing along with the scenario of the fair trial. So they called a mistrial, and the judge ordered them to proceed anyway, and it caused an immediate appeal and all kinds of speculation about the concept of a fair trial and things such as this, the behavior of the attorneys. But not too many attorneys talked about whether or not there'd be feedback, what the consequences of it was, or the consequences were, how the justice system was affected or not affected. What the big question was, how would it affect the efficiency of the court system? So anybody within a mind could figure out justice really had nothing to do with the prosecutors or government's vision of what a court system was. It was putting on the show trials, clearing the dockets, running people through as efficiently and quickly as possible. Another little trick that came up is that attorneys would file motions, and the prosecutors would say, "Well, if you make us have a hearing on your motions, then you can't make any deals. You got to either plead guilty or go to trial." So if you have a weak case or a strong case, it doesn't really matter as whether or not your client wants to run the risk of a trial. And you have bizarre cases like the client might be in Nebraska and plead guilty to something because a jury might not believe his alibi of being in Nebraska at the time of the offense. And you get bizarre results like that. Most prosecutors really didn't care. All they cared about was the conviction. The government cared about the statistical data it was garnering, and particularly in Denver because of the breach of liaison between FBI and CIA and the rearrangement of the Justice Department and their jurisdictional bid to take over, and the big press to establish organized crime as a threat and other threats, the data got skewed. And the feedback became non-existent. And the whole idea of the justice system was efficiency. And then they got the idea much later that we should privatize the justice system. And instead of referring to defendants as citizens or defendants, they would use other terms. They would refer to the police agents, for instance, as consumers. So the government is selling things to the consumers, like, paintballs, lasers, all kinds of things, so-called non-lethal weaponry. It wasn't to prevent crime or whatever. It was marketing to customers, which is the government. Means one branch of the government or one part of the government is marketing to the others, and it's all looked at as a commercial enterprise, again without feedback. Now, I'm going to explore this a lot more in the future in a lot more details, but I'm going to come up with a bunch of examples on how that works. But I can say this, it's not been a good thing for either society or for the whole justice system, because the idea of proof beyond reasonable doubt and presumption of innocence has gone by the wayside. And the whole idea of criminal justice has become a postmodern circus where viewpoints and propaganda take precedent over reality. So it didn't matter whether the defendants in that trial had representation, whether they were guilty or not, whether they got a fair trial or not. The fact is that they had specialists, and the specialists could make sure their rights were protected because that was what their specialized training was, and the devil take the hindmost. It didn't matter because you could say on your statistical data sheet they had a specialized defense, they had people that were trained as specialists, they had a good defense, and these people were better trained than most lawyers that worked burglaries or sexual assaults or whatever. Therefore, they had a fair trial, even though their specialist attorneys had no goddamn idea what the case was about. Tell me where that makes sense. Anyway, please subscribe. Please refer me to other friends. I want to get my subscriptions up a bit. And I thank you very much for watching. Dennis out.